In many countries of Europe, abortion is illegal after the 20th week of pregnancy, more or less the halfway point. In other countries in Europe, abortion is illegal after the first trimester. In many countries, there are certain restrictions placed on abortion requiring that you have some kind of genuine health problem or a genuine risk to the mother's life before the woman can have an abortion. A lot of times people ask me, why can't the United States adopt a law like that? How come a state, an individual state, maybe a very pro-life state, how come an individual state can't just pass a law saying that we're going to outlaw abortion? Well, the answer is a little complicated, and it's based in our Constitution and the role our Supreme Court has. As you all know, and hopefully remember from high school civics class, the Constitution is sort of our foundational law. Normal laws that a state legislature passes or that Congress passes, that, a majority in the House, a majority in the Senate, and the president signs into law, or in California, for example, a majority of the California State Assembly, a majority of the California State Senate passes, and then the governor signs into law. Any individual law like that has to be consistent with the text of the Constitution itself, but it also has to be consistent with what the Supreme Court says the Constitution means. Why? Because the Supreme Court is ultimately the final decision maker, the final authority in interpreting what the Constitution says or means, and how that applies itself to modern day American life. Unfortunately, because of Supreme Court decisions in Roe v. Wade and Planned Parenthood versus Casey, disastrous and terribly incorrect decisions, the Supreme Court has interpreted the 14th Amendment of the U.S. Constitution as guaranteeing a protected liberty interest in abortion, one which states effectively have no power to touch or regulate, outside of small regulations around the peripheries of abortion, requiring parental notification or consent before a minor can have an abortion, requiring certain kinds of informed consent before an abortion, and other things. These Supreme Court decisions, Roe v. Wade, Doe versus Bolton, and Planned Parenthood versus Casey, have effectively stated this, that the Constitution itself mandates that every woman must have the right to have an abortion for any reason and at any point during pregnancy. A normal state law cannot contradict that. It's why it's so important that we get justices on our Supreme Court who reject this activist nonsense and who can affirm that at best, the Constitution has nothing to say about abortion, and perhaps even further, that the language of the Constitution, which says that no state shall deprive any person of life, liberty, or property without due process of law, should apply to the unborn just as well as to those who are born. With this Right to Life thought, I'm John Girardi from Right to Life of Central California.